All right, I'd like to thank all of you for joining us for today's digital discussion hosted by the Consortium for Undergraduate Law and Justice Programs. My name is Haley Duschinski. I'm the president of the consortium. I'm a professor of anthropology at Ohio University. And I'd really like to welcome everyone for joining us today for this very invigorating and exciting discussion on teaching judicial power and reproductive politics post-Dobbs. I'd like to start just by telling you all a little bit about the consortium. Some of the audience members, some of those who are joining us today may be new to this professional network and to this kind of space. The consortium is a professional network for faculty who are involved in teaching law and justice courses and administering law and justice programs, broadly defined, both in the US and globally. And we strive to offer a welcoming and inclusive space. We encourage all faculty who wish to participate in these discussions to please join us through virtual programs such as this one that we're having today, and also through individual or institutional memberships. If you're interested in connecting with the consortium and learning more about the consortium, then I'd invite you to please explore our website, follow us on Twitter. You can reach out to me or to any of the other consortium executive officers, and we're happy to, introduce you to the networks and help you get connected. This year, the consortium is really excited to have launched this digital discussions webinar series, and this is just our second session. Each teaching webinar has a thematic focus. So various webinars may focus on specialized and timely themes, such as our theme today, as well as in the future, more enduring themes such as teaching law and society courses, teaching intro to law and society, teaching research methods or research capstone courses in law and society. So we're planning to offer these, throughout the year on a regular basis and to explore different themes and different types of courses each time that we come together. So for each webinar, we invite several panelists to join us, panelists who have teaching expertise and innovation in the area, to share their teaching insights in a structured format. And then we set aside a lot of time for Q&A and for discussions. We invite audience members to join in the conversation and to share their own questions, thoughts, and experiences on teaching the theme that we're talking about. All of these sessions are video recorded and archived on the Law and Society Association LSA YouTube channel. Our first digital discussion was on the topic of teaching race, police brutality, and the future of policing. That was about a month ago, and that recording is now available on the LSA YouTube channel, if you'd like to go back and take a look. And I also just want to mention briefly another very exciting event on our horizon. The consortium is very much looking forward to our biannual pre-conference teaching workshop. This is the LSA pre-conference. We have scheduled it the day prior to the Law and Society annual meeting in Puerto Rico. So this pre-conference, it's a full day. It's going to be meeting on May 31st in San Juan at the Hilton where the LSA is being held. If any of you are interested in the sorts of conversations that we're having today, then I'd really encourage you to consider joining us for the pre-conference. We're going to have breakout sessions on teaching law and society courses, organized kind of like this virtual webinar. And we're also going to be having breakout sessions on how to build and expand and administer law and justice programs. We'll also have a plenary session on teaching law and justice amidst questions of inequality, sovereignty, and rights in Puerto Rico. We're excited about that. And we'll have opportunities for networking and mentoring throughout the day. So I just want to invite you to please consider joining us for that, May 31st. The registration deadline is this week. And also, I'd like to let you know that we have award stipends to help offset the cost of participation in the pre-conference. These are awards up to $250 with a focus on independent scholars, scholars without institutional funding, and scholars from the Global South. So those partial travel funds are available for the pre-conference participants. They can help offset the cost of travel to the pre-conference and also to LSA if you're interested in joining us. So please let me know if you have any more questions about that. Today, we're focusing on teaching judicial power and reproductive rights post-Dobbs. In June 2022, the Supreme Court overruled Roe v. Wade, eliminating the constitutional right to abortion after almost 50 years. Of course, as we know, the Dobbs decision upended decades of reproductive rights policies and also undermined the court's own legitimacy. And over the last year, we've all been tracking how this decision has transformed American life, reshaped the nation's politics, and also transformed popular understandings of judicial politics and power. So today we've invited our panelists to share with us their strategies and approaches for teaching themes of judicial power and reproductive rights in this new era. I'd like to invite the three panelists all together here at the beginning, and then I'll invite them to share their comments. And then also, as I mentioned before, after our panelists present their comments, we'll be opening up the conversation for audience members. So I encourage you to be thinking ahead about whether and how you'd like to share your own teaching experiences on this topic. And please, if you'd like to make comments using the chat function, feel encouraged to do that at any time. I can moderate chat comments as we proceed throughout the entire session. And also, if you're interested in joining the conversation and sharing your own experiences verbally, we'll have time for that sort of exchange after the panel. Okay, so welcome to our three panelists, and thank you so much for joining us here today. Our first panelist will be Francesca Laguardia. She is a lawyer and an associate professor of justice studies at Montclair State University in New Jersey. And Francesca teaches courses on justice, courts, and legal systems. She's currently just finishing a course that she's been teaching this spring semester called Abortion and the Law. Paul Collins is a professor of legal studies and political science at the University of Massachusetts, Amherst. He's the past outgoing president of the consortium. He's currently the graduate program director in his department. He teaches civil rights and liberties, judicial behavior, law and society, constitutional law and politics, and other relevant courses. We also have Mia Serban. She is professor of law and society at Ramapo College in New Jersey. She's a founding editor of the Ramapo Journal of Law and Society, which has an undergraduate focus, and the pre-law advisor. She teaches many relevant courses, just a few among them, comparative legal systems with a global focus, global reproductive justice, constitutional law, and others. Okay, so with that, I will turn the floor over to Francesca.
Hi, I want to say first, thank you so much for having me here. And I'm really excited to have the opportunity to sit and talk in this panel because the courses that I taught this semester were very unique. My experiences in the courses this semester were very unique. And it's really been sticking with me for the past few weeks, just thinking about how the courses went and what was going on that made them so different. And so I'm excited to have this opportunity to kind of talk about that and explore it a little bit with other people who are doing some of the same things. I teach in the Justice Studies Department at Montclair State University. So my students have interdisciplinary focuses. And I get a mixture of criminal justice students, pre-law students, international justice focused students, and students who are focused on social justice. So from that mixture, you can get an idea that my students tend to be a little bit more action oriented, with maybe somewhat of a less traditional mindset towards law and legal systems than your straight kind of pre-law programs would normally have them be. And this was especially true in the courses that I taught this past semester, which largely consisted of an interdisciplinary group of that, interdisciplinary already group of justice studies students, but then also political science students, pre-law students, and gender, sexuality, and women's studies students. So this past semester, I was teaching two courses that were kind of relevant in this area. One was a selected topics, kind of current events focused course on abortion in US law, and the other was a traditional rights and liberties course. And what struck me really kind of overwhelmingly is just how amazingly engaged these students were with these issues, at this particular point in time. My students, you can imagine, had backgrounds that varied between kind of highly critical focused on rhetorical or narrative arguments, and then some students who were highly critical and sociological. And then also I had some students who really had that more traditional legal and legal institutional kind of focus. My classes, I would say, were focused a little bit more on reproductive rights than on judicial structures, but obviously the two are kind of fundamentally linked here in the United States. And then I wanted to give you that introduction to my students' background because of this intensity of individual interest that I found. So historically, when I've spoken to classes about reproductive rights, about privacy cases, and about judicial power and kind of civil liberties classes, my students have viewed the topic in a fairly remote way, where they're much more willing to sit with the kind of fabricated hypotheticals that the law traditionally uses to discuss power and consistency and rule of law. This year, discussing the cases in the aftermath of Dobbs, in the face of ongoing legal developments across the country, in my abortion class and in my general rights and liberties class, students consistently demonstrated a very personal connection to these issues. And the discussion moved from the kind of traditional hypothetical exploration of rule of law and precedent and judicial power to the types of emotional involvement and responses that I'm more used to seeing in classes when we discuss police shootings or sexual assault, frankly. My selected topics course was an interdisciplinary exploration of the question of abortion in this country. So I kind of grounded the students in Pew polls to give an idea of where the country stands right now. And then I went through readings from Kristen Luker, Michelle Goodwin, Melissa Murray, Ruth Bader Ginsburg, Reva Siegel, Leslie Reagan, Celeste Condit, kind of giving an overview of the process of criminalizing abortion in the late 1800s, the social interests that led to that criminalization, the white supremacist concerns, the professionalization of obstetricians, and then moved into Roe, the conditions surrounding Roe, the cases, the arguments over that time, the arguments since that time, and then the modern cases and modern situation. We discussed pain stigma as well, which is an area comes from the area of kind of medical humanities, looking at the way that society and the medical community view people who complain about medical issues. And then we also looked at racist and gendered medical and social narratives, and we looked at the judicial reproduction and reinforcement of those narratives, how and where they came through in cases, and then also what the discussions were publicly in response to those cases. At times, I found myself teaching sex ed because it's almost impossible to really address the question of reproductive rights and the arguments that are going on in these cases without addressing to some extent the science of reproduction. Although one of the things we noticed is how hard it seems that courts try to avoid having that conversation. But that's also where one of the very interesting aspects of these classes, to my mind, comes in, because teaching reproductive rights to undergraduates is a very particular experience. My students are at an age where they are having personal experiences with abortion or with friends who are having abortions. It's not uncommon for me to have students who already have children or who are pregnant. 4 years ago, when I first started kind of returning to this as a primary area of scholarship, it came up in my rights and liberties class, and a student in the class at that time explained to the class the hardships that she had experienced the semester before, when she, as a young Black woman, gave birth to her second child in the shadow not only of her college studies and her classes and her exams, but also preeclampsia and the steadily increasing maternal mortality rates for Black women across the country. She told the class that if she had known how difficult and dangerous that second pregnancy and labor were going to be, she probably wouldn't have gone through with it, not only out of concern for herself, but out of concern for her older child. 4 years ago, with Roe still strong, that comment brought only a hint of kind of concrete experience into the classroom. But now in my classrooms, students bring up a lot of these stories. They are very clearly afraid. They are infuriated. They are personally attached to these issues, and they're personally aware of many, although certainly not all, of the medical fallacies that underlie many of the opinions in this area. And they respond strongly to those fallacies. I think it's also worth mentioning on that note that I think we lose a little bit of something by having this discussion about judicial power and reproductive rights without also discussing the question of judicial power and Second Amendment debates currently and Bruin. And I found that my students were surprisingly aware of the comparisons between Dobbs and Bruin, the use of history in those cases, the refusal to confront the practical considerations of reproductive science on the one hand, and statistical analyses of gun deaths on the other. So these two areas of what are arguably both public health issues, to my mind, reflect one of the forefront questions that has kind of plagued US reliance on courts, which is to what extent we can hand legal decisions to judges who are untrained in the science that is affected by their rulings. In prior years and in other areas, judicial misstatements, factual inaccuracies have come up in class, but they've led to kind of, laughter, frankly. In this area, in classrooms full of young women who were thinking very much of their own safety, and recent graduates of high schools who experienced routine lockdown drills, the pure inaccuracy of judicial opinions dealing with manufactured notions like fetal pain or abortions, supposedly happening at 9 months, elicits a much more personal and stronger response. In the class situation, that response can be very useful, not only for motivating students in this area where they already feel strongly, but also to concretize the threat that is posed by judicial power. This is power that's wielded by people who genuinely, to be frank, might not always know what they are talking about. Even while students are horrified at the notion of losing the court's protection in this area, the court's clear ignorance in some of these areas also offers strong support for a more limited rights jurisprudence. Courts, at least appellate courts, often do not understand science or do not research the facts of the case. And there's a real question as to whether courts, rather than agencies and legislatures, should be making decisions in areas like the accessibility of mifepristone. Seeing such potent examples of the failure of the judiciary offers students a reason to engage more fully with the idea that judicially protected rights might not always be the best answer to social problems, or that social norms and social understandings might have to change instead in order for real protection to exist. Dobbs is in a lot of ways a reason to limit judicial power, but it's also a reason to limit reliance on judicial power. And it's a very useful reminder that judicial power is already limited. When abortion was legalized through judicial action, there was a backlash throughout the country. In 1985, Justice Ginsburg, who was not a justice yet, gave an address at the University of North Carolina School of Law, which I assigned to my students, arguing that Roe had gone too far. She argued that Roe should have just looked at the health of pregnant women, the argument that Texas's statute was too limiting, too physically risky for women. She described a liberalizing trend across the country at the time. She argued that that would have remained in place if Roe had not reached so far. And by 1985, the writing was already on the wall as to state responses to the idea of a right to abortion, that second trimester protections would shrink back to the line of viability, that the viability line itself would become a point of debate, that states were limiting access to abortion by creating notification requirements, consent requirements, bans on public expenditures, and that courts hated having to look at science in order to balance out these interests. And this idea of crediting doctors' opinions on fetal development, combined with a reluctance to allow women the chance to choose their own interests, their physical interests, their mental interests, and their financial interests over the interest of a potential child, that was immediately distasteful to a lot of courts, let alone legislatures and quarters of the public. And that backlash managed to erode slowly and steadily both access to abortion in the form of trap laws, regulating clinics to limit access, and funding limitations. And that backlash also eroded the ideas of women's value and autonomy that had begun to appear in the debate over abortion leading up to Roe. On top of this came the push to humanize the fetus, the efforts made on the ground to create notions of fetal pain, concepts of a fetal heartbeat, the fetus as a whole person. These were calculated social efforts in response to a disliked judicial opinion, and they managed to seep deep into society, deep enough to overwhelm that decision, which is what we just saw. So I know I've gone on a little while, but in conclusion, thinking about this, getting ready to come here and talk about this, I want to mention that when the announcement went out that I was going to be part of this discussion, I got a very nice email from my own first civil liberties professor, Jerry Rosenberg, who wrote The Hollow Hope, that also outlined a lot of these arguments that Justice Ginsburg made earlier. And he had updated, there's a new edition out, and he had an updated chapter describing the post-Dobbs on-the-ground activism, efforts to lessen the impact of the decision, grassroots funding groups, the possibility of backlash from voters, the clear public preference for legalized abortion, the signs that the public might be ready to act on this preference. And I wrote back to him and told him I always thought he underestimated the impact of Roe, because I did. And I still do. And in fact, much of my work in grad school and my work on abortion more recently has been in large ways responding to his arguments. But still, in my last few days of class, it was those facts that I pulled out with my students. Because if there's one thing that I think we see in that successful attack on precedent and stare decisis and judicial authority, it is that judicial power is limited and can be overcome by aggressive social activism regarding the ideas and the practice on the ground and the details as far as state legislatures and federal legislatures. When I teach MAP, I start with Olmsted. When I teach Katz, I start with Wolf. I start with the case that was overruled. People of my generation, and I think the generation before mine, have held on to an idea that the court was moving forward. And so we've treated judicial decisions as not just supreme, but final. But judges change and cases change. And the society we live in will be the one that runs off of the narratives we've created and supported and convinced others to adopt. Judicial power is one ingredient, one threat, one potential savior, but it's not the only one. And in this post-Dobbs landscape, I think that the argument that we might have started to have with Roe, that Justice Ginsburg thought was sidelined in Roe, it might be that that's really just beginning now. And that's in large part kind of what I found with my students and where I left them. And I'll leave it there, and I'm very interested to hear what everybody else experienced talking about these issues.
Thank you so much, Francesca. That's really gives us a lot to think about. I appreciate your comments. Paul, would you like to go next?
Great, thank you so much, and thank you so much, Francesca. That was fantastic.
No, it wasn't.
Okay, so I'm going to kind of focus primarily on the judicial power part of things, and I'm drawing a lot on my experience teaching a class called Judges and Judging at UMass, where we look at the craft of judging and we do it through an interdisciplinary lens. And so we bring in scholarship from really a wide array of disciplines to think about judges. But I would say overall, the fundamental tenet of the class is that we treat judges as people. And so we sort of start with the idea of taking judges off a pedestal and talking about them as human beings, and as human beings with biases, with cognitive limitations, and a variety of other things that are of interest to the conversation we're having here. And like Francesca, as I've been teaching this class over the past few years, I've sort of noticed a little bit of a change in the way students experience the class. And a lot of the class focuses on, how we pick judges and how different mechanisms for selecting judges might affect the decisions that they render. And then I would say the second half is really how they render those decisions. But some of this can get a little dry. But what I've noticed is that it's not that dry anymore. And that's kind of what I want to talk about today, is how we think about getting to Dobbs, right? And so in order for us to get to Dobbs, not just on the Supreme Court, but in the federal US courts more generally, a really wide host of legal norms were violated, particularly with respect to the way that we select judges, but also with respect to judicial decision-making itself, although I'll probably focus more on the former. And what I'd like to suggest is that talking more about legal norms is really significant, and bringing the importance of legal norms to life for students in light of Dobbs can be really significant, right? It helps them do a lot of things. It helps them really grasp the high stakes in fights over judicial power, right? It seems today that every time a seat on the Supreme Court opens up, it's like the sky has fallen. It helps them grasp why legal norms matter. How do we detect norm violations, right? Because we can see some of it coming before it actually happens. And then probably most importantly, I'd like to get students to think about the consequences of norms. And so, we could ask them, what would happen if this norm was no longer, right? And have them map out what might happen. And so one way of doing this is to think about where we are and then how we got here. And so we're in a weird place in 2023, not just with respect to Dobbs and abortion rights, but with respect to the Supreme Court more generally and the federal courts more generally. We saw that today, right? So the Senate's holding a hearing on the lack of ethical standards for the US Supreme Court. In setting this up, what makes the Supreme Court and the federal courts different today than, say, 10 years ago? I mean, for the first time in modern American history, we have a Supreme Court that can be completely sorted by partisanship, right? Obviously, Supreme Court justices have always been ideological, and many of them have been overtly partisan, but it's different today. Right? Today's the first time in the post-World War II era that we can say, okay, you 6 that were appointed by Republicans, you're all conservative, and you 3 that were appointed by Democrats, you're all liberal, and they sort really nicely and really, really cleanly. And this is very, very apparent to the American public. In the past, we had lots of examples of the David Souters and the John Paul Stevenses of the world, who, although appointed by Republican presidents, would often, or at least not with insubstantial frequency, vote with the more liberal justices. But now it really looks like a completely partisan institution. It's an institution that's making incredibly significant decisions that are way out of step with public opinion, right? So Dobbs is an obvious example here, but as Francesca said, we can also look to the Second Amendment, right? A majority of Americans want stricter gun control laws, but the Supreme Court is absolutely heading in the other direction. It's using a definitionally conservative legal philosophy with all kinds of implications in and of itself, originalism, to justify those decisions, right? And so given what originalism is, and yes, I'm aware that there are liberal versions of originalism, but that is not what is exercised on the Supreme Court. Given what it is, there's not a lot of optimism for progressive students who look at this institution and think of it as a bastion for the defense of rights and liberties. Instead, they look at it, just like we saw in Dobbs and like we see in the Second Amendment cases, as a court that really wants to turn back the clock. And I'm going to kind of set originalism aside for now, because I think it'd be useful to have a whole conversation about the implications of originalism, but that's for another topic. Probably not surprisingly, when you consider all these factors, public support for the Supreme Court is at an all-time low in the modern era, right? So, I looked at a poll today. I think the number was 60% of them, around 60% of Americans disapprove of the Supreme Court. This is not how things used to be. That number doesn't seem to be changing. It seems that the court is going to be facing a tough time if it continues down this path. And it's not just the Supreme Court. The lower federal courts under the Trump administration were staffed with judges who also subscribe to originalism and who are basically working to forward conservative judicial positions. So, if we think about it, all right, here's where we are in 2023. It's important to ask, how did we get here? And this is where I think it's a good opportunity to talk to students about legal norms and to have students identify legal norms, think about what they mean, and then walk through what the consequences of eliminating those legal norms are, of maybe not applying them all the time. We can think about it a lot of different ways. But the Dobbs decision does not come out of thin air, right? It's a result of the ideological Supreme Court, which is the result of an ideological United States Senate, a Federalist Society, a Trump White House, and a lot of other things going on in America. So if we just start with the Republican Senate, this really begins with the Obama administration. And so, at the Supreme Court level, we're talking about Mitch McConnell's invention of the so-called McConnell rule that says we don't confirm Supreme Court nominees in a presidential election year. This undid about almost 100 years, about 90 years of precedent. Since Supreme Court confirmation hearings started in 1939, every nominee who wasn't withdrawn from the process got a hearing and a vote. This is the first time that a nominee doesn't get a hearing and a vote. And so basically it was a big roll of the dice on the election, and Trump won and McConnell won too. But that created a separate problem 4 years later, that a seat opens up on the Supreme Court during another presidential election. And so Republicans quickly jettisoned the McConnell rule in order to ensure that Amy Coney Barrett's appointed to the Supreme Court. So we see there the destruction of a century-old norm with this new rule, and then that new rule, which is really just a norm, immediately gets eviscerated because it's not convenient for stacking the Supreme Court. While all this is going on, other stuff's happening. In order to get Amy Coney Barrett on the Supreme Court, the Senate has to set aside the quorum rule because Democrats on the Judicial Committee didn't give them a quorum. They tried to block Barrett through procedural mechanisms. Lindsey Graham just ignored the quorum rule. And of course, in order to get Neil Gorsuch on the Supreme Court, you have to end the filibuster, right? And so when you end the filibuster, as political scientists suggest, you're going to get more ideological nominees. So a lot of what's going on that gets us here are these norm violations that are happening in the Senate. But then there's other stuff going on over in the Trump White House. One of the interesting issues is farming out Supreme Court nominees and lower court nominees to Leonard Leo and other members of the Federalist Society. There's a position that this is unconstitutional. I don't happen to agree with that. The claim is that it violates Congress's advice and consent role. I think that's overstating Congress's advice role. But the point is that this is the first time in American history that a president is going to let an outside organization, in effect, select members of the Supreme Court and other federal courts. And by doing this, this ensures that the courts are going to be just stacked with overtly ideological individuals, right? Who are faithful adherents to this doctrine of originalism, who have their true blue conservative bona fides. While this is going on, we're watching it at the Supreme Court level. At the lower federal court level, again, goes back to the Obama administration, President Trump appoints hundreds of lower court judges. In fact, in 4 years, Trump appointed one Court of Appeals judge less than Barack Obama did in 8 years. Well, how did he do that? Another norm violation. Mitch McConnell blocked President Obama's lower court nominees during his last few years in office. And so Trump entered office with just dozens of vacant seats that are going to be staffed by the Federalist Society. And an interesting thing that happened with a small handful of these folks Some of them were rated not qualified by the ABA. And ABA rankings have problems, particularly with racial and gender bias, but those problems don't really apply for Trump's judges. He was just outright appointing unqualified people to the federal courts who then were being confirmed. And then, of course, this gets us to this Supreme Court that in Dobbs overrules Roe and basically does what the Federalist Society wants it to do, which is to say, abandon Supreme Court precedents that are not viewed as having originalist origins. And so this is a pretty radical interpretation of stare decisis, that we only respect precedents if we agree that they come from an originalist interpretation of the law. These are just a few of these norm violations that I think are worth exploring with our students. And when I think about them, when I think about, how is this going to play out in the future, I think it's very unlikely that these norm violations will ever be restored. And in fact, it's probably more likely that we're going to see more norm violations. And so one thing that's particularly interesting is the blue slip procedure. And so this is the formal mechanism by which senatorial courtesy operates that allows home state senators to, have substantial input, if not a veto, over lower court nominees in their home state. That this is gone for the Court of Appeals, or at least it appears to be gone for the Court of Appeals. It was gone while Republicans controlled the United States Senate. They're now claiming that the Democrats aren't enforcing the blue slip procedure, which is just kind of funny. But it seems to still exist for federal district court judges, but I'm guessing that might be on its way out the window, which again, this has very significant consequences for these norms that are put into place to mediate the tendency of presidents to appoint extreme ideologues, not only to the Supreme Court, but to lower courts. And so, what I'm kind of positing is that when we talk about norm violations, they really have very significant consequences, particularly in the post-Dobbs era. Without the destruction of these really significant norms, some of which were almost 100 years old, we would not be talking about what we're talking about today. And so I think it's a good opportunity to get students to think about the importance of these legal norms, to identify what these legal norms are, and to think through the consequences of undoing some of these norms. So I appreciate the opportunity to share a little bit, and I look forward to the conversation.
Thank you so much, Paul. We'll now turn to our third panelist, who is Mia. Would you like to share your thoughts?
Yes, I am going to share my screen. Can you see it? Awesome. Thank you so much. Thank you for having me. I will shift gears, if that's okay, in two ways. One, from the domestic, from the US to global and comparative approaches, and two, to a specific class, actually, and specific students, and talk a little bit about that. So I teach at Ramapo College of New Jersey, and I'll tell you a little bit about that, a little bit about the program, a little bit about the course that I taught this spring, Global Reproductive Justice, a little bit about some of the key approaches, pedagogical and otherwise, that I thought about, some of the successes and failures of this course, and then some of the key lessons for the future. And this, of course, started out, it's not just right post-Dobbs, but really Dobbs was the opportunity to actually rethink very seriously how we teach issues of reproductive justice and reproductive rights in the United States. We had at Ramapo a panel, post-Dobbs implications, so on, in the fall. There was enormous student interest. So that prompted us in the Law and Society program to think about offering a course in the spring, which we did as a topics course. So Ramapo is a public liberal arts college. Not everybody knows it, so just two words about that. Northern New Jersey, we have about 5,000 students, around 20 students average per class. So that was my expectation in terms of who was I going to be teaching. Not necessarily all from the Law and Society program. In the Law and Society program, we have a mixture of students who are interested, like Francesca's students, a mixture of students who are interested in criminal justice, law school, and everything in between. So that's very broadly the setup. In Northern New Jersey, I would say skews democratic, although not, it's fairly, I would say, mixed. And our students, again, are a very, very mixed bunch. So the course was Global Reproductive Justice, and I am giving here the description. It is grounded, yes, in the reproductive justice framework developed by Loretta Ross and Ricky Solinger. The reproductive justice book was one of the required books for the course, but what I wanted to do was shift the focus for the students. And shifted for two reasons. One, I expected that it was going to be a very personal topic, as it turned out to be, but I wanted them to look from the outside in. So that was one of my key approaches. Look at comparative studies, comparative cases, other countries, as well as at the international level, the international human rights framework. So I took the reproductive justice framework developed domestically, and I moved it, or at least attempted to move it at the global and comparative level. So the description is, in that sense, nothing extraordinary, right? I focus on the dimensions, the three dimensions developed by Ross and Solinger: the right to have or not to have a child, the right to parent one child with dignity, and the rights to sexual autonomy and gender freedom. And I was really, really ambitious because I really wanted to cover everything. Yes, which turned out, didn't work out that way. I also wanted it to be as immersive an experience as possible. So part of the course requirements, and some of this has already passed, was for students to lead class discussions on specific readings, to present on specific countries of their own choice, both orally and in writing. And at the end, which is coming up, by the way, on Thursday, their final is a policymaking exercise, again on a topic of their choice, in small groups, 3 to 4 students. So that is very briefly the setup. I thought quite hard and long about how I am going to introduce this topic to a group of students that I expected to be, I'm not going to say all necessarily supporters of reproductive rights, but clearly the interest was coming from that direction, right? So those were the expectations. And I wanted to give them a very, very broad experience. I also wanted them to not jump straight into abortion. Right, I wanted to provide solid theoretical foundations, both from an intersectionality perspective, the history of reproductive justice perspective, as well as a human rights, because the human rights foundation is crucial for reproductive justice as an approach, as a framework, but also for the independent units that I wanted to touch upon, which were the right to, so yes, abortion, contraception, reproductive health, fetal protection, population growth in the first category. So I didn't touch upon really everything, but I tried. Parenting with dignity, and here I focused on poverty and incarceration, transgender and non-binary rights, and then sexual violence and reproductive justice during conflict. I already mentioned a little bit about expectations, what my expectations were. What was the reality? The reality turned out to be a group of 22 students, most of them, but not all of them, from the Law and Society major. That was probably the most diverse group of students I've ever had. And I cannot think of a single dimension that was not represented in this 22, in this group of 22 students. In any way, shape, or form you can think of, it was there. From politically extreme left to extreme right, across race, ethnicity, gender, sexual and gender identity, autonomy, first generation, poverty, students whose parents had been incarcerated or themselves had been incarcerated, students with children, on and on, right? So that was the reality that I faced with a syllabus and a course design for a somewhat different group of students. So that was the challenge in a sense, but also turned out to be one of the best courses ever, as it turned out. And finally, a little bit about positionality. I grew up in Romania. I am one of the children in Romania of so-called Children of the Decree, which was a decree adopted by the Ceausescu regime, the communist regime, that banned abortion completely. And I am one of those children, right? So this is my positionality, my background. Also a background grounded in reproductive justice and reproductive rights globally in some of my prior prior work, and in human rights and practices of human rights. So I wanted to bring all of that to my students because I really wanted to shake them, right, in a good way, but I wanted to shake them. And I wanted to offer them different ways of entering the post-Dobbs world in the United States and place the United States in a global and comparative context, which can be difficult, right, for any number of reasons. So these were my three bases: human rights, and I spent actually a fair amount of time on this, about 3 or 4 weeks, on human rights and international human rights law framework, on concepts of power, and on intersectionality. And I brought intersectionality, of course, not just from the domestic level in the United States to global levels. And they responded actually very, very well. And I need to sort of specify that, because my hope was that once I built that framework for them, that once we got to questions and issues and topics, abortion, right, the responses would be grounded in this, rather than knee-jerk reactions or other kinds of political or ideological debates. And to a certain extent, it worked. It worked for everything except for abortion. So that was one of the sort of lessons. I wanted width and I wanted depth. So I structured the class such that even when I didn't get to discuss everything between the readings, the students leading individual class discussions on specific readings, the country studies, and the final policymaking exercise, we would be touching upon everything, sort of like a 360 view, right? With abortion, contraception, some key points, but key points that are interrelated and part of a much broader conversation on reproductive justice. And I was hoping that once they saw those connections and they understood how discussions of abortion or contraception, for example, are grounded in international human rights law, they would have a somewhat different understanding of US developments. So what were the successes? Well, the successes were an extraordinarily robust class in terms of class discussions. And that's both a success and a failure. A success because they truly engage with each other. A failure to the extent that, particularly in the first half of the semester, the class discussions, even with my moderation, often turned difficult and painful. No lines were crossed, but they were difficult conversations where we started from common grounds, theoretical grounds or otherwise, and then sooner rather than later, students sort of reverted right to their predetermined ideological positions. So that was one. A massive success was the country studies, I would say. And I have here just a little bit. I just wanted to show you the kinds of topics the students chose and worked on. So obviously this is just a selection. So they included everything from infertility, reproductive healthcare, reproductive health in Germany, conflict, reproductive rights in Syria, parental rights in Brazil, female genital mutilation in Somalia, India, population control, and more, right? Abortion, contraception were big topics. But they also chose very interesting formats. I won't talk about that, but somebody, for example, did a newscast. Their presentation was a newscast. So they played around with it, and they were very well received, and they were very supportive of each other. Now, in terms of failures, there is a long way to go. I would say that the theoretical grounding and the comparative angle helped tremendously. It opened their eyes to the multitude of reproductive justice issues in different contexts. And because they did not come to them with preconceived notions or even a lot of knowledge about specific countries, right, and had to learn that almost from zero, they made a lot of success in that understanding how to make connections with domestic developments. So that was success. And yet, my last point, interactability. And by the way, we spent about 3 or 4 weeks on abortion. Despite my attempts to contextualize and position abortion differently, they really wanted to talk about it, and I created that space, and we did talk about it. Historically, from a judicial power perspective, medical perspective, any lens, every lens, we actually talked about it. But I believe we ended up where we started. While they listened and learned, I did not get the sense that I actually made a significant difference when it came to this one issue, right? So that's a question for the future. What are some of the key lessons I took from this moving forward? The comparisons in the global focus always help. And of course, I've taught, right, in this space, not necessarily on reproductive, but human rights and other topics for a while. So I knew this was, I knew this was going to work. This was a true and tried technique. So this is something that I will keep. The grounding of reproductive justice in international human rights and human rights more broadly, again, I think is an absolutely necessary ingredient moving forward, also because it brings the human rights language to the United States and brings it to students that they can then take to other courses and other topics and other, right? I was centering while decentering the US. The US was always the backdrop. While I actually took US off the table, they were not allowed to do a country study on the US. That was our point of reference for everything, right? From history to concepts to, so that also worked, I would say, reasonably well. Abortion continued to be a sore point is not really the word, but it was not as successful in terms of what I wanted to achieve as I was hoping, right? The scope of the course, I was way too ambitious. Nonetheless, I think I will keep it because for them to see the connections and to understand reproductive justice as a whole, I think is essential. I would like to bring in more experiential activities, both on campus and off campus. Those that they did were very successful. I gave them extra credit, but I didn't really incorporate them thoughtfully in the course design, which is something I'll probably do for the future. And again, I need to be very careful, and I would recommend this for everybody teaching on this topic after post, right? Balancing a little bit more realistically our expectations of who our students are and what they bring to the classroom versus, right, who they actually are and what they bring to the classroom. And constructing our syllabi and our course design with that in mind. I had some serious challenges, for example, with extraordinarily conservative students, and moderating those class discussions was a real challenge. And I should have really thought about that ahead of time, a little bit more ahead of time. So I think I'm going to pause here, and I'm looking forward to our discussion.
Thank you so much, Mia, and thank you all three panelists. These were just really thought-provoking presentations. I appreciate so much that you all kind of approach this as an opportunity to talk with us about what you have been trying in the classroom and what's working, what you want to continue working on. I mean, these are all kind of works in progress, right? And the landscape is changing all the time. So I think your presentations help us reflect on that. I just had maybe an initial thought or two, just briefly with a question that I'll kind of pitch to the panelists, but also these are comments and questions that I think many folks here in the audience could address. So I'd like to invite others to kind of join in the conversation as well. And again, please, as you have your own thoughts and questions, I encourage you to post questions in the chat or perhaps raise your hand and we can call on you that way. Listening to your presentations, of course, I was struck by the extent to which your pedagogical, your teaching approaches were shaped by the students' personal engagements and personal investments in the topic at hand. I mean, it sounds as though students are coming to these classes, the classes you're teaching, because they view these topics as a vital part of their own lived realities, right? And they want to understand what's happening around them, what's happening to them. They're hoping to develop some conceptual frameworks, right, for making sense of the world around them. And this adds a special element to the classes. And so, as I heard all of you talking, you're kind of offering the way that you're thinking about the larger conceptual frameworks that you're trying to help them make connections to, right? Whether it's larger conceptual frameworks about, judicial decision-making and scientific expertise, judicial norms, global human rights frameworks, you're giving them these conceptual frameworks to help them make sense of the world. And so I'm kind of interested in asking you a follow-up question about a little bit more about like specific assignments, specific things that you did in class to try to help them make those connections. I think all three of you touched on this, but I'm interested in like, what did you find that has worked? I haven't taught in this particular area, but I'm thinking about analogous teaching areas, that I've experienced where students have this very personal investment and personal engagement. It can be difficult sometimes to really think about how to design assignments that enable them to make that movement from their personal lens, their immediate lens, up to the broader conceptual framework. So I think that's one question. And again, if others have comments from the audience, we welcome that too. Then the other thing that I was thinking is, all of us in one way or another are involved in different kinds of law and society programs, law and justice programs. Our courses don't exist in a vacuum. They're part of a larger curriculum, right? In one form or another. And I think all three of you mentioned the interdisciplinarity of the students and the classroom context for this particular course and how you had to take that interdisciplinarity into account. So I was kind of thinking about, for this topic in particular, I'm sure there's a very different way that you would think about teaching these topics for first-year students, as opposed to students who are, perhaps seniors or something like that, right? It's a different kind of endeavor to think about how to design those sorts of classes or exercises. So I guess I just wanted to ask a question to ask you to kind of reflect on, how your course then fits within a larger curriculum, right? I mean, you're talking about your course objectives in this particular course, and students may or may not meet the expectations that we have a particular moment for a particular course, but we also are teaching in larger kind of programs. And so there's a trajectory that they're following. And so sometimes our courses, students may or may not meet the expectations in the course, but it helps them, their building blocks to help them get to where we want them to be by the time they finish the program. So I guess this is just kind of a question about how you viewed your courses fitting into a larger curriculum, and any insights you might have around that.
So, I think in large part what Mia laid out is a great kind of structure, right? In terms of starting with a theoretical perspective. And then when you're asking for writing assignments, I find the way that because I do end up addressing a lot of these emotional issues in my classes, and maybe a little bit unlike Mia, I often have students on extremely divergent ends of the spectrum in one class going at each other. So it was something that I expected a little bit more coming in. Actually, I expected more of it than I got. But then I think when you start with a theoretical perspective or a series of theoretical perspectives, and then can structure writing assignments to say directly that they need to refer back to that perspective, it forces them to come out of themselves a bit. And I think that's kind of what Mia was describing. Correct me if I'm wrong. And I find that works really well. I think in my rights and liberties class, it's very straightforward, because we are going to, throughout the entire class, we are discussing having to go back to precedent. How would you relate this to the prior case? How would you discuss this case in the context of everything that has come before? What rules can you distill? And then how would you apply them here? In my interdisciplinary class that was focused on this, I had students with a number of different theoretical perspectives coming into the class. And actually, I was shocked by how well prepared those students were. So I'd be more interested in other people's responses, because I had less work to do in that area than I usually do. Because those students who came in who were the most interested students in this area were also very motivated in terms of what theoretical perspectives they had already developed. My pre-law students in that class were very impressive in terms of their ability to go back to doctrine and try to apply it, trying to distill rules. My gender, sexuality, and women's studies students had very strong theoretical perspectives that they distilled all of the material through. And so actually for me, I guess because it clearly was an advanced class, and then thinking about, I don't know that I would try to do that. I don't know that I would try to do that as a first year class. I think I would bring it in as a topic in a first year class that was very carefully guided through whatever theoretical perspective was a part of that class. And I don't know that I would try to do a seminar just on this issue at an earlier level.
I can, Mia, go ahead. I saw you were gonna go. Go ahead, please.
No, I think if you go in order, it keeps things.
Okay. Yeah, I'm happy to say a little bit about how I think about my class in terms of where it fits into our curriculum. So I tend to have primarily seniors in this class on judges and judging. And I don't always think about it this way, but I think I'm trying to accomplish two things. And one is I'm sort of like the foil to all the constitutional law that they get from other professors. So I believe it or not, I teach a whole class on judges and judging in which they do not read a single court opinion, because that is not what my class is about. My class is about thinking about the craft of judging and thinking about the biases that enter judges, thinking about the power that judges have, thinking about how we can constrain or expand that power and things of this nature. So it's really interdisciplinary. It was never designed to be a class in which they really get deep into legal doctrine. Like we talk about, originalism, for example, but it's not the purpose of that discussion is to sort of understand the benefits and limitations of originalism. And then the second part of this, and I think this is actually more intentional, is that I want them to be better decision makers. And so when we're talking about biases that judges face, we also talk about how we can avoid those biases as everyday decision makers. And so there's a good 3 weeks in this class that it's social psychology. They're reading Thinking Fast, Thinking Slow. They're taking cognitive response tests and understanding, how to shut down automated responses and things like that. Basically, I mess with them for a couple weeks. And the idea is to get them to be better decision makers while understanding that judges do all this stuff too. And we have to understand that in order to comprehend the law more generally, we have to understand that judges aren't these sort of mythical geniuses that are immune from all of this stuff. So that's kind of where I see that class as fitting in our curriculum.
So we have, as of right now in the Law and Society program, we have both a globalization elective category and a social justice elective category. We're in the middle of a sort of curricular transition, but we will keep the core. So a course like this and other courses that I've taught in the past, even though they were not specifically focused on reproductive justice, right, fit very well as electives, and they are taken by students in their junior senior year. Like Francesca, when I teach right, first or second year 100 or 200 level courses, I introduce some of these topics very sort of gingerly as we move along. And our curriculum has always had an international, pretty strong international aspect to it. So it fits in that sense very nicely, right? The assignments, so that I tailor the assignments, like the country study one, it's not necessary that I can just pick a country and sort of run with it. Once the curriculum, right, once the syllabus is set out and we have the topics that we're going to focus on, they actually have to research that particular topic for that particular country and then link it both to international human rights law, right? They have specific questions, what conventions has the country, so on and so forth, and to our beginning of the semester theoretical discussions. I think I have asked them literally almost every class this semester, when you think about this particular issue, are you free from the power of others to live your life as you see fit? And right, the sort of key power questions. until I think hopefully by now they've internalized that particular lens, for example, right, which is also crucial for the human rights framework. I would say that has worked well. That has worked well. It does, of course, require consistency, right? It does require quite a bit of I'm not going to say wasted because that won't be correct. The things that I thought we were going to focus on this semester and the issues that I thought were going to be controversial turned out to be significantly less so than I expected. Others turned out to be significantly more. So as a concrete example, when we were discussing human rights in the beginning of the semester, universalism, relativism, a pretty important topic for later in the semester, and I thought that I would introduce the hemline controversy as a nice sort of easy way in. That turned into an extraordinarily controversial topic. They debated it for more than a week. I let that conversation move on, but that turned out to be a turning point for them, for example, as opposed to others that I thought were going to be significantly more controversial. So, yeah, I hope that answers the question.
Yeah, thank you all so much for sharing those thoughts. And again, I'd like to invite anyone in the audience. We would love for this to be, interactive with the audience. I know many of you have taught these themes or have considered how you might teach them in a course in the future. And so we'd love to hear your own comments or your questions for the panelists. I guess one more question that I have again for the panelists in the meantime, and Mia, I think that you've kind of spoken about this a bit throughout your discussion, but I'm wondering, given the experiences that you've had now across maybe this year, the last year, teaching post-Dobbs, how do you think that you might shift your course the next time you teach it? What changes might you make, or what adjustments might you make to try to experiment with something different?
Should I go first? I would keep the core. I might perhaps choose to go more in depth, a little bit more depth rather than width, although I would lose some of the key connections I want them to see. For example, they responded very, very well to thinking about reproductive justice when we talked and when we started from the perspective of non-binary and transgender rights. They saw connections they hadn't seen before, and I assigned queering reproductive justice as the reading for that particular section. They responded very well. They saw connections they hadn't seen before. So if I were to give something up, I would be rather reluctant, but I would probably be very thoughtful about some of the things that I might keep and some that I might not want to keep. I would add experiential activities definitely as a key component in the course from the very beginning. And I would ask them to make more connections explicitly, and I would have to work it into the course design, between US and global and comparative approaches, a little more direct comparison, which I haven't really done so far. So those would be three of the things that.
And Mia, you mentioned a couple of times experiential assignments or experiential exercises. What kinds of experiential exercises do you think might?
So for example, one of the ongoing conversations right now at Ramapo pertains to menstrual justice. And while I'm aware of it and some of the efforts our Student Government Association is undertaking in that regard, from tampons in the bathroom, for example, to adding more gender-neutral bathrooms and other things, also not just menstrual justice, I hadn't really thought to incorporate that, right? Part of their final exercise is actually about thinking, okay, now that we've identified all of these issues, now that we've talked about all of this, how do we move forward? What do we do concretely, right? So thinking like a policymaker. well, this is thinking like a policymaker on the local level, right? So I those kinds of efforts, but there were others that students brought up in their hometowns, for example, in there, right? So those could be really very nicely integrated into the course from the very beginning. And I sort of did it a little haphazardly as I was moving, right, as I was moving along.
Yeah, I appreciate that. Those are interesting comments. You know, I was thinking as all of you were talking, I was thinking about, you know, to the extent that the students are feeling this, feeling their personal investments and their personal engagements with the topics that you're discussing in class, those personal experiences are, of course, they're living them in particular locations and context and places, right? So also navigating, I mean, Mia, you're talking about the domestic and the global context, but also then there's this very, very local, whether it's the campus community or their hometowns or even just the state level, right? There's also the more local context that is part of that triangulation.
So I think along that line, one of the things that I had running through this course was I had professors coming in also from public health and from medical humanities and giving kind of guest lectures at certain points during the class. I also had David Cohen from Drexel, who wrote a couple of articles with Greer Donnelly and Rebecca Repuchet. He was nice enough to come in and talk to my class also. And then we wrapped up with a panel made up of an associate professor at a local medical school, the director of health equity from Planned Parenthood Federation of America, a representative from Planned Parenthood Metropolitan New Jersey, and a representative from a local activist group in our area, kind of coming together and discussing where issues were at that time and what kinds of battles people are in the process of fighting right now. And I had arranged those things in large part, frankly, around the schedules of the people that I wanted to come in and talk to the class. I'm not sure if I could arrange that differently because I need to deal with the schedules of the people who came in to talk to my class, but I think it would have been nice to have those running more thoroughly throughout the beginning of the semester and kind of guiding it along for a larger portion of the semester. I think also I didn't really I had response paper assignments for a couple of those that students had to respond to a couple of those guest lectures and a major paper at the end that I haven't had a chance to see what I would change about it because I haven't had a chance to see what the students have written yet. But I think I would also add in a few more written assignments over the course of the semester just to be able to kind of keep on top of things. Although one of the things that I liked about the way that I am doing things right now is that I use online reading software and that does social annotation software that allowed me also to prepare for some of those more difficult conversations, because you see where the students start to have the large explosions with each other. You see it in advance and they don't do it as personally with each other. And then you can be a little bit more prepared to guide those conversations as you go through and kind of help what might be minority opinions in the class to have their opinion expressed in a less confrontational manner.
Would you use the social annotation software again for this kind of class for that reason? I mean, that sounds...
In part for that reason, and in part because it also, frankly, I love that software for a few reasons. It also lets me see students who are afraid to say things in class and see that they are involved and that they have, you know, great ideas. And a lot of times there are students who I just never would have noticed in prior years who pop up with this stuff. But yeah, I like that it gives me the opportunity to prepare for these major arguments. And also, frankly, if the student is too afraid to make the argument themselves at that moment, which might be completely understandable because they might be 1 or 2 students out of 30, right? It gives me the opportunity to try to find a respectful way to make the argument or to start that argument off so that we can have the conversation without it exploding.
Any other thoughts?
Yeah, I appreciate the opportunity to add a little. So one of the things that I think I'm going to change in my judges and judging class is throughout the semester, I have the students do some small work group, and it's usually about 4 or 5 times they work in small groups, and they're usually sort of concrete but abstract type decisions, like I'm trying to think of one off the top of my head that they do. I give them a scenario in which they're members of a hospital board that has to decide which patient is most deserving of a life-changing procedure. And of course, there's no right or wrong answer, right? It's just to try to get them to think about their values and how their values might shape their decision making, to think about stereotypes. It's sort of in each of the characters, there's embedded information that can activate biases or not, et cetera, et cetera. And I tend to keep those fairly abstract, but it's occurring to me, especially in light of some of what's been said today, is that I don't necessarily need it to be so abstract. And so I'm thinking about, especially because I think students are more interested in judicial power than they used to be, that we can talk a little bit more concrete about judicial decisions that have a real impact on their lives. And so I'm interested in changing that, moving it away from some more abstract principles to something a little bit more concrete.
If I can add something, based on what Francesca was saying, I try to get around to the same thing, right? So I have discussion questions throughout the semester that they answer, and when I go to class, so variation on that, which I think a lot of folks use, right? So you have an idea of sort of what's coming and you can prepare. I found those to be pretty useful indicators in terms of how students engage with the materials, with the discussion, the questions that I asked them, how they respond to each other, right? They engage by the time we get to class. So that helps. But I like also Francesca's thing, so I might steal it.
Okay, are there any other comments, of course, from the panelists? Anything else you would like to add before we close? And we have time for any questions from the audience as well. Any final comments or questions?
I had a question for Paul. So Paul, making the end run around the filibuster is a violation of norms. The filibuster would have been a violation of norms as well, right? So to my mind, there's a little bit of a where do we begin here question, right? Which, I mean, I guess that's my starting off bias, is that a lot of this is much more the underlying narratives and ideas about the law, but kind of how do you address that, starting from that position, and which one you address as the violation?
Yeah, that's a great point. It's funny because I typically start from like what I call the modern era, right? So that but the filibuster comes along, not randomly, but it comes along, right? It's interesting. I've never had a student ask me about it. I don't have a good answer to this question, because you're exactly right? So, you can make a very strong argument, and probably a correct argument, that, the system was never designed to have this sort of 60 vote majority in order to confirm a judge. And then the Senate adopts the filibuster, guts it for lower court judges, leaves it around for the Supreme Court until Neil Gorsuch comes along. Yeah, I mean, it suggests to me, I really like this question, the need to maybe draw out the development of the norms in the first place, right? And so I do this with respect to, like, why do we have Supreme Court confirmation hearings, right? And what's the public role and things like that. But I don't really do it with the filibuster. I love the idea, and I'm going to challenge myself to think through it and have a better answer to that question. Thank you.
And I actually, I do have a question that's come in over the chat, and this could be a big question, but I might just ask, especially panelists, if you have any thoughts to at least kind of help us think through this a little bit. The question is, what advice would you have for junior faculty or junior scholars who are starting to teach these topics in red states? It's a big, because it's not just, it could be many topics.
I can go first. So I taught in Texas for most of my career. So my first job was in Texas, and I taught in Texas for 9 years, and then I've been at UMass for about the same amount of time now, and that was very different. So, what was my major strategy in Texas, and how does it differ? So I sort of felt a greater need to do my best to approach any issue and explain arguments on both sides, right? And so at UMass, because we have social justice in our mission, I don't feel quite as obligated all of the time, in particular, to make arguments that I ethically don't agree with. And this can be tricky, and I'll give you a great example, which is before I moved to UMass, I had made a decision to stop teaching same-sex marriage because I didn't feel that I could ethically make an argument for why it should be illegal. And so I struggled with it for many years, making both sides of the argument. And then I just felt that I couldn't personally do it anymore. And so I decided I never got to this, but I had basically made a decision that, okay, this is the last time I'm teaching this topic. I'm just going to swap it out for something else. And this was something where I would teach, towards the end of one of my classes, like controversial subjects, so to speak. But I just felt that I couldn't do it anymore. And so, this is a tough issue, and it's something that I think about a lot because, not only my teaching, I teach a whole class called Bias in the American Legal System that could get me fired in other states. Like I have a book coming out about racial and gender bias and the way we pick judges that could get me fired in some states. And so I recognize that I have a privilege of teaching in Massachusetts, who not only allows me to teach these subjects, but actually wants me to be teaching these subjects. And it's tricky, and it's a hard line to figure out how to walk. Yeah.
I don't think that there's much that I can add to that, except to say, I think that is a very serious concern right now. And especially for junior faculty who are starting to deal with it, make sure that your department is behind you on it. I don't want to be too fear-mongering, but I would say possibly try to avoid some subjects unless your department is going to be behind you on it. And then also, yes, I think most of us, I would hope, at least start out with the assumption that we should try to represent the best possible argument on the other side of any given debate. And that is definitely something I still try to do in all of the topics that I teach. And I try to represent from the best of my abilities, the best possible argument I can think of for all of the students who are sitting in my class that I disagree with. They need to know that I will not dismiss their arguments out of hand, and that I think there's at least some legitimate way for them to have come to the conclusion that they have come to. And so it involves several deep breaths and trying to replace yourself in that mindset. But I will say, maybe because I started out teaching a lot of counterterror policy, I have often worried about students recording classes or where an errant sentence could end up. And I think in today's climate, it's a legitimate concern. And so it's worth in advance talking it out with your department and your chair, and knowing where you stand in your university.
Couldn't agree more. That would be the starting point for me. And I think all the three of us are lucky in that regard. It is not something that I'm concerned with from my college or given the state, so on and so forth. But yes, it would be it's a serious concern in a lot of places. And I think it's a fair approach to weigh the pros and cons of teaching certain things right now versus waiting. And then definitely without departmental support, that's going to be very hard. But also in terms of I've taught now for a while, and I have had any number of students across every spectrum I can think of. I can sort of handle it. But I've had some issues in the beginning, when I started teaching. I sort of ventured very enthusiastically into certain things without, and stumbled, let me put it that way, a little bit. So I would also wait, I will wait a little bit. I think a lot of it is, we learn as we teach, right? We get a lot of experience. The more courses we teach, the more students we have. And these topics might be, and I jump right in, and right now I'm not afraid to teach anything, and not just because I have the backing of my department or my school, but because I'm reasonably confident that I can handle it. But I would say I would agree with what both Paul and Francesca said, and I would also I would also wait a bit. Not just for those reasons, but also experience teaching reasons.
I think that all makes a lot of sense. I think that's all good insight and advice. I was kind of reflecting on some years ago, I was tenured at this point. I had the opportunity to teach a kind of a course that was designed as a first-year course. That was a kind of survey of different timely issues in law and society. And we were able to co-teach that class. So there were a few of us that were teaching it. One year it was 2 of us, one year it was 3 of us, one year we had 4. And we were all from different disciplinary backgrounds. And so this, and we were addressing a lot of topics. We were kind of going through different timely issues. And I think that they would be the kind of topics that, well, I would not really want to design a class like that just to carry it all myself, right? But the idea that we had these different people co-teaching the topics together. So the way that we organized it is we were able to all say, here's this issue, this contemporary issue. This is how I see it as an anthropologist. And my colleague would say, this is how I look at it as a historian. And this is how I look at it as a criminologist, right? And so that introduced this idea of a multiplicity of perspectives that actually really helped us manage a lot of that. And this isn't a big lecture class. We had like 100+ students in there. So I don't know, that's, of course, that's not always possible. And this was a special situation, but sometimes just thinking about techniques like that so that it's not, there's diversity of perspectives introduced into the design of the class. The other thing that I found to be effective in some cases is to actually find ways of introducing first-person accounts or experience-based accounts into the classroom, because that brings a different kind of dynamic, I think, into. So I know for a number of years we've had, in this class actually, and in some others, we've had a panel of formerly incarcerated individuals from prison that we have kind of a partnership with, who kind of come in and talk about what their experience of incarceration was like and what their experience of reentry was like. And they're able to tell it through their own lens. And it hits the students differently than if it's one of the faculty members kind of telling them what they're supposed to think about it in the class. And also using novels and different kinds of sources, like novels and memoirs, I found are very effective. It does change the dynamic a little bit, and the conversation can take different forms, I think, when you're actually working with someone's first-person accounts. This might be a topic for us to explore in a little more depth in a future webinar, actually. Okay, I think we're just about out of time. I want to thank everyone for coming today. Thanks to those of you who have stuck with us through the whole session. And thanks so much to our three panelists. We really, really appreciate you taking the time and the energy and the investment to share your thoughts and reflections with us. Thank you so much. And yeah, we look forward to continuing these discussions at the pre-conference and then in the virtual webinars as we move forward. Thank you all. And if you'd like any more information about the consortium, please send me an email.